Hi, my name is Helen Ward, and I'm the president of Kids First Parent Association of Canada. Welcome to part 2 of our 4-part video series on parent-child rights and education and suggestions for legal action to address some of the current concerns. Let's get started. To share the screen here. Get going on the presentation. Okay, so yeah, we're Kids First Parent Association of Canada. We're at www.kidsfirstcanada.org. Please join and become a member and donate. So this is what to do when education personnel violate parent-child rights. And this part 2 is about what is happening in schools now and what changed. So there's different sections. First section, what is happening? It's about contested beliefs, diversity challenge, secular and pluralistic in the School Act, about the minister's responsibility. The second section is on what changed. 1, power imbalances between the parents and the state. 2, curriculum changes. 3, professional autonomy. 4, learning resource selection policy changes. 5, a new strategy for safety and bullying, and 6, opt-out changes. And then we'll conclude with a timeline of the legal cases and policy changes that we're dealing with. So know your history because it often repeats. In the 1800s, devout Christian believers like Edgerton and Ryerson, pictured here, set up a system of compulsory attendance in tax-funded state-run schools, and he also helped to set up the residential school system. And these things could take place because there was no human rights laws to protect parent and children's rights from this gross intrusion of the state onto their lives. I want to talk about this issue of contested beliefs. So any belief which is widely disputed, do we have God, or is there gods? Immortality, is there a soul? What about sexual morality or any morality? What are schools for? What should be taught? All these things are contested beliefs. And more beliefs are becoming contested. For example, you might think that 4 plus 4 equals 8, and probably most of us do, but some people would contest that because the existence of so-called objective or absolute truth is increasingly contested. And all this is fine. But the state itself, as in state-run schools or state schools, is prohibited from having beliefs. The state cannot have beliefs. And so there's a policy or principle of state neutrality on beliefs that comes from our Charter of Rights and Freedoms. So the school system discriminates against parents in order to impose contested beliefs. In the past, Christian believers used state coercive power to impose their beliefs and practices on children in state-run schools. And this was discrimination against non-believers, against non-Christian parents and children. And this discrimination ended after legal action against it. But now education leaders are again apparently using state coercive power to impose beliefs and practices on children. In the BC School Act, the term secular is used, and most people might assume that this means not religious. Yes, so the schools must be run on secular principles and non-sectarian, and they must inculcate the highest morality according to Section 76 of the School Act. But the Supreme Court of Canada has interpreted this term secular in the BC School Act. It was interpreted in the infamous Surrey School Books case, and secular. This idea is that the school system must respect the rights and freedoms and beliefs of all students and parents and community members, and so it cannot endorse or favor or discriminate against or in favor of any one belief or religion or philosophy or moral perspective. So that's how state neutrality actually looks in a school. There's no preference for any particular belief set. And in the School Act's preamble, where it sets out the purpose of the school system in BC, we see that all its members, all are to receive a good education, or education anyway, and that all learners are to have this education so they can contribute to a healthy, democratic, and pluralistic society. So the fact that BC is pluralistic is baked into the bones of the system. Pluralism means we have different beliefs. They don't all agree about everything. And of course, we have diversity. Like, we like to celebrate diversity, but it's not just about, do you want pizza or kimchi or sushi? It's about diversity of belief. And so diversity of belief is difficult and can and does cause conflict. How do we deal with it in a school setting? And so I call this the diversity challenge. So including and respecting all at school is difficult because, well, we do have diverse, irreconcilable beliefs about many contested matters. And this includes diverse beliefs about what should even be taught in schools. And school is a unique environment. School is not the public square where equal participants freely consent to associate with each other, as in freedom of association, and to express themselves, as in freedom of expression, freely, and then can choose to leave when they want. Education system relationships, our associations, are not entered into by consent. Children are legally required under the School Act to have an education program. So they're required to have an education program, but these public schools are currently the only free option. So most families have financial concerns about sending their kids to an independent school where there's fees, maybe very high fees and other costs, or homeschooling has significant opportunity costs, including loss of income and then lots of cost to pay for the homeschooling things and stuff and time you need. So parents are effectively financially coerced to entrust their children to public schools. So this is not what we do call freely given consent. So the education system currently forces strangers who have incompatible, diverse beliefs and practices to associate intensely for many days, for many years, or for most days of many years. But an education system that respects diversity, inclusion, and equity is possible. Parents have the authority over the education and moral upbringing of their children. That's according to the Supreme Court of Canada, to the United Nations Convention on the Rights of the Child, and many other international human rights agreements. So how about providing an equitable public education options that are inclusive of all by respecting both diversity and parental authority? Parents who want one thing should have that. Parents who don't want that, want something else, give them something else. It shouldn't be that difficult. It's a matter of logistics. And in fact, the government is required to provide free, respectful, inclusive education system for all students. That's a requirement. Yeah, so I'd say the government is failing to do this. And it's the Minister of Education, well, basically it's the Minister of Education and Childcare now. It's that person's responsibility, has the responsibility for curriculum and learning resources. That's according to the School Act. So it's all this comes down to the Minister of Education. So causes of these changes. Number one, there is a power imbalance between parents and the state. And getting into one particular gross example of that is the Infants Act, which provides so-called mature minor consent. So in 1973 and 1992, there were amendments to the very ancient Infants Act. Healthcare providers can decide that a minor under 19 in BC can refuse or consent to healthcare without parental consent. And schools have been promoting clinics that do not require parental consent for decades now. So that was a thin edge of the wedge, maybe. So this licensed healthcare providers can do this, but they are supposed to, okay, so our school counselors and youth workers who are employed by schools considered to be licensed healthcare providers because they may provide preventative or therapeutic services under the Infants Act. Regardless of whether these people are included or not, the healthcare provider must adequately assess the minor's capacity, their maturity, their understanding, their information, all this, their capacity to give informed consent or informed refusal of healthcare treatment. we know that healthcare providers rarely, if ever, very rarely do an assessment at all, let alone an adequate assessment of the child's capacity to give informed consent. People will say, well, we can't, parents might be abusive if their child does something they don't like. But if abuse by parents is suspected by an education personnel, they are legally required to report that suspicion to the Child Protection Services, also known as the Family Policing Services, the BC Ministry of Child and Family Development. Simply assuming that parents will or do abuse their children, that's discriminatory. That violates the Human Rights Code's prohibitions on family status discrimination. So you just can't just assume that and act on it as if it's true, because that's just flat out discrimination. And it's illegal to withhold information from parents. The Infants Act does not say that healthcare providers can withhold information from parents. However, healthcare providers are routinely acting as if it does permit this. And education personnel and other government-funded personnel have also illegally withheld information from parents. So withholding information about our children from parents is a gross violation of parental obligations as well as parent-child rights and related laws. For example, Family Law Act, Education Professionals Codes of Conduct, Infants Act, School Act, Human Rights Code, the Charter, international agreements like the Universal Declaration of Human Rights, etc. So our organization, Kids First, believes that the BC Infants Act and all laws on so-called mature minor consent must be struck down. These laws are unjustly discriminatory and violate parent obligations and parents' and children's rights protected in many laws. And we could use there could be a charter challenge that could strike down that law. So education personnel who believe that they have a right to withhold information from parents are wrong. They may believe that they're protecting children's rights. They are not. The BC School Act entitles parents under Section 7 to be informed in accordance with the orders of the Minister of the student's attendance, behavior, and progress in school. So you are not entitled to withhold information from parents. So let's get into the second cause of the changes to the system, and that's curriculum changes. So what's called an education program in the School Act, that means curriculum. What do they teach? So in 1995, there was a new, I think it was at the first time, that changed the curriculum where this thing called personal planning was added for the kindergarten to grade 7 curriculum, and I believe other similar courses were added at that time. So the newly required courses mandate routine violation of students and family members' privacy. Curriculum requires students to reveal and discuss their own and their family members' private life, personal information, inner life, family structure, family life, out-of-school activities, diet, goals, beliefs, etc. So that was a new concept in curriculum that was introduced, I believe, in 1995. So this created conflict because differences between students and families' beliefs and habits and practices are exposed by this requirement to talk about your personal stuff and your private life. And so conflict results. There's less common ground, and peaceful coexistence between our divergent peoples and beliefs in our society is harder to achieve. So we divide and conquer the population by exposing our differences more. So there's been more recent curriculum changes, items on that if you want to look at these more carefully. The new curriculum says, this has a section on valuing diversity. Teachers should ensure that classroom instruction and resourcements reflect sensitivity to and diversity, and incorporate positive role portrayals, relevant issues, and themes such as inclusion, respect, and acceptance. This includes diversity in family composition, gender identity, and sexual orientation. And has to do this for all students, but that's a very limited notion of diversity. There's no mention of diversity of belief, of conscience, of diversity of religion, Those and culture are not mentioned in this. Again, there's honoring diversity. It's not happening. And the new curriculum has this concept of 3 core competencies: thinking, communication, and personal and social. That's when we're going to focus on this personal and social core competency. That's where the student's inner life and their personal life is the curriculum. There it is again, personal and social, student's identity. Talking about yourself, your beliefs, your identity is the subject. And these categories are divided into 3 sub-competencies: personal awareness and responsibility, positive personal and cultural identity, social awareness and responsibility. Again, focusing on the student's own personal beliefs and things. Then sub-competencies have facets, 6 profiles, those are levels, connections and illustration, those are suggested lesson plans and assignments. So quickly go through some of this. Okay, positive personal and cultural identity, personal values and choices, personal strengths and abilities. Recognizing personal values and choices in your family, in your relationships, and your community. So you're going to talk about you and your family and your family members. In these profiles, different levels of this, you see the focus on I am, my identity, my identity, my identity. So these illustrations are suggested lesson ideas. You can take a closer look at them if you want. There's lesson topics, or I am the so-and-so family. We are all related. My identity, personal interests, family relations, goals for the future. This is actually none of the school's business. Personal narrative. How we know who we are. Identity recipes. Fulfilling needs. Students identify their needs and how those needs are met. Identity. Personality trees. Talk about your personality. Make a picture of it. Put it on the wall of the school. Let people look at it. What is a family? So these topics are all like private, personal topics. And we need to recognize that and teach our children that and tell the schools that this is private, personal information, and you don't have it's none of your business to talk about our own stuff. And then in the curriculum, there's things called boundaries and consent. These are requirements to teach in the curriculum. And you see a contradiction here. So boundaries and consent are part of the physical and health education curriculum from kindergarten to grade 12. It used to be PE, phys ed, but now it's physical and health education. And we see that there's actually routine violation of normal boundaries and consent by much of the curriculum, not all of it, so much of the curriculum. This is the kindergarten physical health education thing. If you click on these things called elaborations, you get more details. There we go. Boundaries, understanding personal boundaries, emotional boundaries, consent, affirmative consent. Yes means yes. I guess no means no too. But when do children actually consent to even being in school, let alone to have anything about school? And what are we putting this in there for? Parents barely consent either because they don't have the options to make other choices because this is the only free option. And in the grade 8 PHE curriculum, the issue of sexual consent comes in. Again, boundaries, consensual intimate activities and images. But so this is right into the curriculum, and that's a core problem, but it's in the curriculum. So third cause of changes is this concept of professional autonomy. So professional autonomy means teachers, not only teachers, but primarily teachers, being able to teach the material as they see fit, evaluate as they fit, and use resources as they see fit. Evaluation of in-course materials, like what should they use? And the questions of who determines this? Well, parents are not included in this discussion. Who determines anything? Resource assessments. Again, that's resources means books, videos, posters, handouts, anything, displays that are in the school. So there we go. Yeah. So sorry the professional autonomy is actually in the collective agreements of almost all of the teachers in almost all the school districts. Okay. So the school boards can challenge teachers' decisions, but that doesn't usually happen, does it? So causes number 4 is it's changing to learning resources. So what are learning resources? Learning resources means anything used for learning, teaching. Books, videos, handouts, posters, displays, websites, magazines, assignments, pamphlets, anything that's in the school. And resources are there to support the curriculum. So if curriculum requires something, then you're going to need resources to support it. So learning resources are currently a source of complaints in education if you're not aware of that. Students, parents, teachers, and members of the public may be concerned that a learning resource is illegal, harmful, or inappropriate in some ways, or violates their rights in some ways. And usually the concerns are about sex-related topics. So sex gets everyone's knickers in a knot and heated up. That's how it is. And that's pretty typical. And there's contested beliefs about sexual matters, identity matters. The complaints could be about any matter. So these 1995 curriculum changes that brought in this personal planning stuff led pretty much directly to the a learning resource legal action in December 1996. A Surrey kindergarten grade 1 teacher, James Chamberlain, sought approval for 3 books that depicted same-sex parented families, because discussing your family and different types of families became part of the curriculum in 1995, and then some 1996. We need some resources. So he sought approval for those. He had a list. The books came from a list made by the Gay and Lesbian Educators. That's Gale, BC. And went all the way to the Supreme Court. James Chamberlain was the main appellant, and Murray Warren, who was later Murray Korn, was also an appellant. There we go. So legal changes, curriculum changes, resource changes. So there was, in 2017, there was 2 changes to the resource selection policy. Sorry about that typo. The policy, there was individualization of the policy and privatization. So in 2017, the Ministry of Education offloaded selection of learning resources to boards. Previously, the ministry had made lists of approved resources, so almost all resources were on those lists, but boards were also allowed to approve of resources. But now the boards had the entire responsibility, and boards also had to make a policy for appealing or complaining about the learning resources. A lot to dump on boards, actually. This is the policy. You can slow down and look at it if you want more carefully. And so when the boards had this responsibility, basically pretty much all the boards offloaded the selection of learning resources onto individuals, individualization, teachers and principals or librarians. Here's an example of the Vancouver School Board Administrative Procedure on Selection. See, many people are involved, but the responsibility rests with the principal in Vancouver. In other places, it's the teacher or the teacher and the principal. So it varies depending on your district. You can look at your policies in your district. So what was the impact of individualization of the resource selection process? Well, parents and students cannot know what resources will be used. You have no idea. You cannot know what will come into a classroom. There are no standards. Education personnel are legally free to choose virtually any resources they see fit according to their professional autonomy. And parents or students, if they want to, or are forced to make formal complaints and appeals to address concerns, and they're ill-equipped to do that. And basically, they're not told the process. You've got to kind of dig around and find it out. Also, in 2017 was the privatization of the collection and approval of learning resources. So the 2017, the provincial government still had this thing called Education Resource Acquisition Consortium, ERAC. which would compile lists of resources so that boards could use them and teachers could use them. But then it changed, and so we have something called the Focused Education Resources Society, which was formerly ERAC, and also the ARC Foundation, which provides SOGI 123 resources. So in 2019, the ERAC thing was folded into the Focused Education Resources, and that is a private organization, it's a nonprofit society, just as Kids First is, but it's funded by the BC government. So you have a nonprofit society providing the lists of resources rather than the government. So what's the impact of privatizing public education and learning resources? Well, nonprofit societies do not report to the legislature. And the salaries of nonprofit societies employees are not on the public record. Like teachers and other administrators' salaries are all on the public record. You can look them up. So there's no transparency and accountability to the public and to the MLAs, the elected politicians, is not possible with private groups like nonprofit societies and foundations, like the ARC Foundation. So causes number 5, there was something called the strategy for bullying and safety that came in. So we need to look at the case of Azmi Jubran. It was a bullying case. In 1996, Mr. Jubran made a complaint to the BC Human Rights Tribunal against the North Vancouver School District. He was terribly bullied for 5 years in high school, and this included being called homosexual slurs. He said he was not a homosexual, and his bullies said they did not think he was. The Human Rights Tribunal ruled that the North Vancouver School District was responsible for the bullying by students, and the district had to pay $4,500 to Mr. Jubran. But the district is only financially liable if the bullying has something that's covered by the Human Rights Code, some kind of discrimination that's in the Human Rights Code. And sexual orientation discrimination is covered by the Human Rights Code. So if the child was called like ugly or fatty or jerk or something like that and bullied, that's not covered by the Human Rights Code. So the district would not be liable. So districts want to avoid liability for what the students do. So this is a quote from an article. Ken Neal, Safe and Caring Schools Coordinator for North Vancouver District, says, the insurer for all school districts has made the decision to pursue the case to the Supreme Court because of limits on liability. So it's the school districts have a concern to cover their financial butts because of liability concerns. The students are bullying each other. There's no Human Rights Code aspect. They don't have to pay up, but if there is, they will. So the Ministry of Education got busy to do this and produced something called in 2003, Safe, Caring, and Orderly Schools, a guide. And then also, actually 2004, it created the Safe, Caring, and Orderly Schools policy because, again, they're trying to have a policy saying we're doing what we need to do to our due diligence to deal with bullying, and so we won't be liable, which is, of course, reasonable. And then in 2005, the Supreme Court of Canada ruled on the Jubran case and basically agrees with the BC Court of Appeal that the school district has to provide a safe learning environment, upholding the Human Rights Code provisions. So in 2007, the ministry required all districts to create codes of conduct that protect the grounds in the BC Human Rights Code. Actually, that was not the Supreme Court of Canada's decision, but it was put in. So the categories in the Human Rights Code have to be mentioned in these codes of conduct. And that includes race, color, country of origin, religion, political belief, sex, age, disability, sexual orientation, and 2016 also included gender identity expression. So these Human Rights Code provisions have to be mentioned in the codes of conduct in schools. And then they would need to do things like have workshops, post the code of conduct, inform people about the code of conduct so that people are informed, and then the district is exempt from liabilities. It's done all those things, they're not liable for the bullying that may happen in the school or through the school. So these are some quotes from the Jubran case that people might want to reflect on because they might apply in your particular situation or situations you're aware of. A school board has a duty to maintain a positive school environment for all persons served by it. We teachers, students, and parents, anybody else. The school board has a duty to provide the students with an education environment that does not expose them to discriminatory harassment. And there's this concern with BC Human Rights Code that we foster the full participation of individuals in the life of British Columbia in a climate of understanding, mutual respect, and equality of dignity and rights. If you're experiencing that in the school system, that's fantastic. If you're not, you might have grounds for legal action. So bullying strategy came in under health and safety issues like earthquakes, pandemics, selling soft drinks. So it's not curriculum, it's strategy for safety. So these are two students who suffered extreme bullying in school, Mr. Asmi Jubran. And now we'll talk about Amanda Todd. So Amanda Todd was sexually extorted by an online Dutch child predator and bullied at her schools. And in 2012, at the age of 15, she committed suicide. It was a very high-profile situation because she released a video about her situation that was shared internationally, very, very widely. So this happened, and then BC started called the ERASE strategy. And ERASE means expect, respect, and a safe education. I believe Christy Clark was the premier at the time. So Amanda did not, the codes of conduct did not, Human Rights Code did not prevent what happened to her. So district and personnel, school personnel, are exempt from liability as long as they follow the code of conduct policy. So here's the ERASE strategy page. There it is. Every child deserves an education free from discrimination, bullying, harassment, intimidation, and violence. Every child feels safe, accepted, and respected. Is that happening for you and in situations you're aware of? Yeah, and the ERASE started with the Safe, Caring, and Orderly School strategy in 2004. It goes back basically to the Jubran's case. In 2016, the Human Rights Code was changed in BC to include gender identity and gender expression. 2016 and 2017, the Ministry of Education added SOGI, sexual orientation and gender identity, to the ERASE bullying strategy. So this comes in to the anti-bullying safety strategy. And in endorsing, adding SOGI, they endorsed what I would say is a contested belief that everyone has a sexual orientation and gender identity. It says it right there. So the Ministry of Education decided the SOGI component of the ERASE strategy needed learning resources to support it. But do we have learning resources to support all the different categories in the Human Rights Code? We don't. Is there a special strategy for all those different categories? Religion, disability, and all that? SOGI 1, 2, 3 resources are optional, so teachers do not need to use them because it's not curriculum. It's a strategy. And teachers who don't want to teach SOGI don't have to, and teachers who want to can teach it. So basically, it gives the green light to teachers who want to do this, to bring this up. Yeah, so there's the resource policy, SOGI 1, 2, 3, coming in under ERASE. Here's SOGI 1, 2, 3 resources evaluated by the Focused Education Resources. They're evaluated resources. They are pre-approved. You can use any of these resources. Yeah, there we go. They're all approved as age appropriate and all the rest of it. And the Focused Education Resources Society says that the SOGI resources are recommended for all grades, kindergarten to grade 12 for English, and also for physical and health education, as well as a few other courses too. And of course, a teacher could choose to use these for any, because they have the professional autonomy to choose them for anything they want. Yeah, they basically can choose any resources they want from SOGI or anywhere else in accordance with professional autonomy. So what is SOGI 123? Where did it come from? It is produced by something called the ARC Foundation, which is a private, belief-based proselytizing group the government partners with. I mean, the government does not anymore, anyway, partner with the Catholic Church or Jehovah's Witnesses or the Mormons or whatever to create resources, but it partners with the ARC Foundation. And these are so SOGI's 123 provides lists of approved books, videos, and lesson plans and teaching suggestions. These are just some of the lists of books. I'll just go through this quickly, and you can slow down if you want to look at them more carefully. Picture books to discuss LGBTQ plus history. Picture books to discuss gender identity. So picture books are for very young children. Nonfiction books, and there's other recommended online book lists as well. We're not sure if those are also pre-approved, because those are just even more resources you could use. So SOGI 123 was founded by the BC government, the ARC Foundation, BCTF, and other activist groups. It says it's right here. Created by ARC Foundation in collaboration with BC Ministry of Education. And the ARC Foundation says that SOGI 123 is its #1 priority. We are focusing all efforts on SOGI 123. There. And its focus is schools, so that's pretty clear. Who funds the ARC Foundation? Well, you do, we do. There's the provincial government is a sponsor or funder. And who funds SOGI 123 and the ARC Foundation? British Columbia and the federal government are its funders, so we fund it. So let's talk about the 6th cause of change. That's changes to opt out. So opting out is when parents just tell their teacher that we don't want our kids to participate in something for whatever reason. And the formal name for that is alternative delivery. So the parents would be asked to provide the education in some other way. So the Corrins were a same-sex activist couple. No problem with activist couples or same-sex activist couples, that launched this human rights complaint in 1997 seeking representation of and access to and for groups across the full range of gender identity and sexual orientation in curriculum. And in 2006, the government reached an agreement with the Corrins, this couple, so it's an agreement, didn't have to go to court. And the Corrins were given the right to review all curriculum, all grades, all courses, and all learning resources for inclusion of same-sex relationships. The Corrins were very opposed to parents being permitted to opt out their children from any teaching related to sex. Some districts do allow parents to opt out their kids for sensitive or controversial issues, especially in the physical and health education components and the planning courses. So against the Corrins' wishes, opt-out was provided but very restricted. The government allowed kids to be opted out of these sensitive issues only in health and planning courses like PHE or career and personal planning. There's various names for these courses on different years, but no other opt-out was permitted. But still, some districts will notify parents about these courses, but when these topics are being brought up. So some districts do that, some don't. Yeah, there's the policy, alternative delivery policy. Go and but in 2017, basically BC opted out of opt-out altogether, because when they brought in the SOGI 123 strategy, or under the erase strategy, and they brought in resources for SOGI 123. This permits staff to insert SOGI topics and SOGI 123 learning resources and any other resource as they wish in accordance with professional autonomy. In any topic, in any course, in any time, in any grade. Because again, it's not curriculum, it's a strategy. So you can't really opt out of things like that. Because sensitive issues can be raised at any time by staff or by students or by contracted businesses, such as Salima Noons that comes in to teach whatever they teach, so-called sex education, without notifying parents. Teachers can't, might ask students, do you have any questions, or bring in any book or anything you want, or talk about any topic, give a speech about any topic that you want. And so there's there's like no control over what can be brought up. So parents can't be notified. So the changes in policy mean that teachers, librarians, principals, boards, districts are probably acting within the new policy, even when parents and students object to instruction and related learning resources. So we have disempowered parents, curriculum changes, professional autonomy, learning resource selection policy changes, and minimal or no opt-outs. So staff are permitted basically to teach anything and use almost anything, any learning resource they want. Remember, government needs to provide free, respectful, inclusive education system for all. I'm going to go through a quick timeline, and you can look at it more closely later about the legal cases and changes to policy and Human Rights Code that brought these things into being. So 1872, do not forget the beginning of the whole thing. BC made school attendance compulsory. 1995 was the Egan case, where sexual orientation was made analogous to sex in the charter. In 1995, we had the new curriculum that adds this personal planning, this privacy invading curriculum. In 1996, Canadian Human Rights Code added sexual orientation. In 1996, the Surrey school books case happened with James Chamberlain and Murray Warren, later Corn, being appellants in that case. In 1997, the Corns launched their human rights complaint seeking coverage of sexual orientation in the curriculum and learning resources. In 2000, same-sex couples obtain the same benefits as other common law couples. In 2002, the Supreme Court of Canada ruled on the Chamberlain, the Surrey School Books case. All books, they need to basically include, system has to be inclusive of all and respectful of all. 2002, that was the beginning of the human rights case by Mr. Gibran against the North Vancouver School District. And then that initiated the Safe, Caring, Orderly Schools process with a guide. In 2003, the BC marriage license for same-sex couples. 2004, Safe, Caring, and Orderly School strategy was started, which later became erased. 2005, the Supreme Court of Canada ruled on the Gibran case, upholding the decisions made at lower court. 2005, the same-sex marriage was redefined to include same-sex couples. 2006 was the Corn Agreement with the BC government that started the review of the curriculum. 2007, the School Act was amended to require every district to have a code of conduct that includes protected characteristics in the BC Human Rights Code. 2012 was Amanda Todd's tragic suicide. In 2012, BC started the Erase Bullying Strategy. In 2016, gender identity and gender expression were added to the BC Human Rights Code. And the next year, 2017, the learning resources policy was changed, privatized, and individualized. In 2017, also, the SOGI thing was added to the erase strategy. And all those resources were added as pre-approved resources. In 2019, the BC government privatized the resource selection and folded ERAC into this Focused Education Resource Society and allowed ARC Foundation's SOGI 123 resources to be included. So there you go. That basically concludes this second part of the 4-part discussion or video series. I hope it's been helpful. I hope this is useful, and you'll find evidence, sources for evidence and arguments and legal cases that are applicable to this situation. So thanks for listening, and please take the time to review all 4 of the videos. Thank you.